everyone. On the eve of the Independence Day, let us see few important judgment since independence. So इस वीडियो में हम देखेंगे few landmark judgment which have transformed India. Let's begin the video with the Keshwanand Bharti ka case, which is one of the landmark judgment in the Indian history. So the first case is Keshwanand Bharti Shripad Galveru versus State of Kerala. Citation is 1973 Supreme Court. It was of 13 judge bench. In the Keshwanand Bharti case में the issue behind the court was कि क्या parliament जो है वो amend कर सकती है any part of the constitution or there is some limitation to the power of the amendment of the parliament. So in this case the issue before the court was कि क्या parliament amend कर सकती है any part of the constitution या इस पे कोई restriction या limitation है, and the court has held that by the 13 judge bench कि parliament can amend any part of the constitution provided the basic structure of the constitution cannot be altered. तो सुप्रीम कोर्ट ने by 7:6 मेजॉरिटी से ये हेल्ड किया था कि कॉन्स्टिट्यूशन जो है उसे अमेंड तो किया जा सकता है बट बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन शुड नॉट बी अल्टर्ड. बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन को बिना चेंज किए हुए पार्लियामेंट कैन अमेंड एनी पार्ट. नाउ द क्वेश्चन अराइजेस, what is that basic structure of the constitution or basic feature of the constitution? क्योंकि इसे बिना alter किए parliament has the power to amend. Supreme Court has yet not defined what exactly constitute the basic structure of the constitution, but through various judgment Supreme Court ने ये point out किया है कि what all will constitute the element for the basic structure of the constitution, like supremacy of the constitution, rule of law, independence of judiciary, free and fair election, judicial review, etc. तो various judgment से सुप्रीम कोर्ट ने ये बताने की कोशिश की है कि what exactly will comprise under the basic structure of the constitution, because the parliament has the power to amend the constitution provided basic structure of the constitution cannot be altered. Basic feature को बिना alter किए parliament जो है वो amend कर सकती है any part of the constitution as laid down in the case of Keshwanand Bharti Shripad Galveru versus State of Kerala in the year 1973 by the apex judiciary, that is the Supreme Court. The next case is Indra Nehru-Ghani versus Narayan. Citation is 1975 Supreme Court. It was 5 judges bench case. In this case, 39th constitutional amendment was challenged before the apex judiciary. 39 constitutional amendment ने insert किया था article 329A under the Constitution of India. And as per article 329A, it says that if there is any election to the president, vice president, prime minister or the speaker of Lok Sabha, that is beyond the scrutiny of the constitutional court. Yani as per the article 329A, which was inserted by 39th constitutional amendment, it provides कि if there is any dispute with respect to the election of president, vice president, PM, speaker of Lok Sabha, that cannot be questioned in any court of law. It is beyond the jurisdiction of all courts. It means as per this provision, this is beyond the judicial review. Hence, the court have struck down the clause 4 and 5 of article 329A on the grounds that it violates the basic structure of the constitution. क्योंकि अभी हमने देखा कि in the Keshwanand Bharti case, the court has held that parliament amend तो कर सकती है constitution को provided it should not alter the basic feature of the constitution, and judicial review is one of the basic feature. और इस आर्टिकल के थ्रू what they have provided कि it cannot be challenged in any court. It means they are hitting the basic structure of the constitution. Hence the apex judiciary has struck down clause 4 and 5 because this says that कि इनको तो हम किसी भी कोर्ट में चैलेंज कर नहीं सकते. So as they are violating the basic feature of the constitution, hence the court have struck down clause 4 and 5 to article 329 of the constitution in the case of Indra Nuggani versus Narayan in 1975. Another case is Maneka Gandhi versus Union of India, and the citation is 1978 Supreme Court. It was 7-judge bench case. In this case, the issue involved was कि क्या right to go abroad is a fundamental right or not. तो कोर्ट के समक्ष ये इश्यू था कि क्या right to go abroad is a fundamental right under Article 21, that is right to personal liberty, and the court said yes, right to go abroad is a fundamental right as enshrined under Article 21 under the right to personal liberty. कोर्ट ने ये बोल दिया कि right to go abroad ये पार्ट है personal liberty का under Article 21 of the Constitution of India. Now the question arises कि क्या इस fundamental right पे there is any restriction? Answer is yes. That restriction can be through a procedure established by law. तो right to go abroad को सुप्रीम कोर्ट ने हेल्ड किया कि ये तो फंडामेंटल राइट है अंडर आर्टिकल 21 राइट टू पर्सनल लिबर्टी के अंदर, बट इट कैन बी रिस्ट्रिक्टेड curtailed ऑन द ग्राउंड ऑफ प्रोसीजर एस्टैब्लिश्ड बाय लॉ. प्रोसीजर एस्टैब्लिश्ड बाय लॉ के ग्राउंड पर इसे कर्टेल किया जा सकता है. नाउ द क्वेश्चन अराइजेस व्हाट इज रिगार्डिंग द प्रोसीजर. सो कोर्ट ने इन दिस केस इटसेल्फ हेल्ड दैट कि जो प्रोसीजर होगा इट मस्ट बी फेयर, जस्ट एंड रीजनेबल. इट शुड नॉट बी द फैंसीफुल, ऑपरेसिव और आर्बिट्री. यानी जो प्रोसीजर लॉ के द्वारा एस्टैब्लिश किया जा रहा है जो कि कर्टेल कर रहा है वंस लिबर्टी, right to personal liberty, it must be just, fair and reasonable. It should not be arbitrary, fanciful or oppressive as held in the case of Maneka Gandhi versus Union of India. In the Minerva Mills versus Union of India, whose citation is 1980 Supreme Court, it was decided by the 5-judge bench. In this case, the constitutional validity of 42nd Amendment Act of 1976 was challenged before the apex judiciary. 42nd Constitutional Amendment is also known as a mini constitution. And with what respect it was challenged in the case of Minerva Mill? It has inserted 2 clauses. 42nd Constitutional Amendment ने add किया था clause 4 and 5 to Article 368 of the Constitution of India. Article 368 of the Constitution of India provides for the amending power of the Parliament is being given under Article 368. Clause 4 says that Parliament's की जो amending power है, amendment की power है, that cannot be challenged in any court on any ground as per the clause 4 to Article 368 जिसे इंसर्ट किया गया था 42nd Constitutional Amendment of 1976. उसमें ये बोला गया था क्लॉज 4 में कि पार्लियामेंट की जो अमेंडमेंट की पावर है उसे हम चैलेंज नहीं कर सकते हैं ऑन एनी ग्राउंड, बी इट द कॉन्ट्रवेंशन ऑफ पार्ट 3rd ऑफ द कॉन्स्टिट्यूशन. पार्ट 3rd प्रोवाइड्स फॉर द फंडामेंटल राइट. इट मींस कि अगर फंडामेंटल राइट ब्रीच हो रही है, वॉयलेट हो रही है, by some amendment of the parliament, then that also cannot be challenged as per clause 4. It cannot be challenged in any court. Clause 5 of the article 368 says that parliament has the unlimited power. Unlimited power है parliament के पास when it comes to the amendment power. So these two clauses are violating the basic structure, the basic feature of the parliament की amendment की power से basic feature of the constitution is being violated, because parliament की power to amend does not says that it has the power to destroy. तो इन दो clauses को invalid held किया गया था, and they have been struck down in the Minerva Mill versus Union of India, because they are giving unrestricted power to the parliament. Clause 4 बोल रहा था कि किसी भी ground पे, be it the contravention of fundamental right, parliament की amendment की power cannot be challenged in any court of India. Clause 5 says that it has unlimited power. So these two clauses has been struck down by this Minerva Mill case, and that's why the validity of 42nd amendment of 1976 जिसने insert किया था clause 4 and 5 to article 368 was challenged, and as it violated the basic feature of the constitution, hence these two clauses has been struck down by the apex judiciary through a majority of 4:1, because in the Keshwanand Bharti, which comprises of 13 judge bench, जिसका judgment आया था by 7:6 majority, where the court has clearly emphasized कि parliament amend तो कर सकती है any part of the constitution provided it does not violate the basic feature of the constitution, basic structure of the constitution को बिना alter किए parliament can amend any part of the constitution, whereas these two articles are in contravention of that. That's why the court has held in the case of Minerva Mills versus Union of India that these two clauses are unconstitutional, which are added by the 42nd amendment. The next case is Muhammad Ahmed Khan versus Shahbaz Begum. Citation is 1985 Supreme Court. It was delivered by the 5-judge bench. In this case, the provision of section 125 of the CRPC was before the court. 125 of the CRPC provides the provision for maintenance. Issue behind the court was कि क्या a Muslim woman has a right to get maintenance under the provision 125 of the CRPC, and the court said yes, because 125 of the CRPC is a secular provision. It is applicable to all irrespective of the religion of the parties. तो 125 जो है वो secular है character में, it is different from the personal law for parties, and it is applicable to all irrespective of their religion. Therefore, a Muslim woman also is entitled to get the maintenance from her husband under section 125 of the CRPC. तो 125 of the CRPC secular है character में, इसलिए Muslim woman जो है वो maintenance claim कर सकती है by invoking section 125 of the CRPC, because it is secular in nature. It does not have to do anything with the religion of the party, as laid down in the case of Muhammad Ahmed Khan versus Shahbaz Begum in the year 1985. In the Indra Sanghi versus Union of India and others, judgment was delivered by the Supreme Court in 1993. It was 9 judges bench which has delivered the judgment, and in this case the article 16 clause 4 was before the court. Article 16 clause 4 provides for the reservation in jobs to the other backward classes who are not adequately represented in the service. तो आर्टिकल 16 क्लॉज 4 जो कि रिजर्वेशन देता है इन जॉब्स टू द अदर बैकवर्ड क्लासेस हु आर नॉट एडिक्वेटली रिप्रेजेंटेड इन द सर्विस, इसकी वैलिडिटी was challenged in this case and the court held that it is all constitutional. And जो रिजर्वेशन की बात यहाँ कही गई है टू द अदर बैकवर्ड क्लास, इट इज बेस्ड ऑन द कास्ट, नॉट ऑन द इकोनॉमिक बेसिस. इकोनॉमिक बेसिस पे दिस रिजर्वेशन इज नॉट गिवन इन जॉब्स and court has held that 25% reservation to the other backward class is all valid with 50% cap. Maximum is 50%, and the creamy layers under the OBC, they are not entitled to get the reservation. So in this case the court has held कि reservation देना in job to the backward classes on the ground of caste, not on the ground of economic basis, that is all valid, and 20% reservation for the OBC is valid with 50% maximum cap is there, and the creamy layers under the OBC are not entitled to get the reservation as laid down in the case of Indra, Sanghi versus Union of India and others in the year 1993 Supreme Court by the 9-judge bench. In case of Vishaka versus State of Rajasthan, whose judgment came in 1997 by the Supreme Court, it was 3-judge bench. Vishaka was an NGO and this NGO has filed a petition in the Supreme Court on the issue of sexual harassment of women at workplace. So NGO Vishaka ने फाइल किया था एक petition in Supreme Court regarding the sexual harassment of women at workplace, and the court has framed a guideline जिसे हम विशाखा गाइडलाइन बोलते हैं. The apex judiciary held that every person, be it the woman, has the right to work with dignity at the workplace. So, right to life में under Article 21, right to work with dignity is also included. And we should provide a safe working environment for women which is free from all kind of harassment including sexual harassment. And the court through the Vishaka guideline had made it mandatory हर organization के लिए, चाहे वो public sector का हो या private sector का, to have a mechanism to deal with the complaint of sexual harassment of the woman at workplace. So this case has highlighted the issue of sexual harassment of women at workplace, और इसको देखते हुए सुप्रीम कोर्ट ने गाइडलाइन फ्रेम की थी जिसे विशाखा गाइडलाइंस बोलते हैं. And the court has held that it is the fundamental right of every woman under Article 21 to work with dignity. It means she has the right to get the safe working environment which is free from all kind of harassment. And pursuant to this Vishaka guideline के आने के बाद one act was enacted in 2013, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013, which provides a mechanism to check the cases of sexual harassment of women at workplace. So this case had made it mandatory for every organization to set a mechanism to deal with the complaint of sexual harassment of women at workplace. In the case of National Legal Services Authority versus Union of India, whose judgment came in 2014 Supreme Court by the two-judge bench, and this for the very first time in Indian history have held that transgender will be considered as the third gender other than male and female. Thus, transgender has been given a legal recognition for the very first time in the case of National Legal Services Authority versus Union of India in 2014 by the apex judiciary. And the court has held that every person has the gender identity. Gender identity means personal experience of one's own identity. So under Article 21, every person has the right to reveal his own gender identity, and the third gender has been recognized. The transgender को third gender recognition दिया गया था through this case, and it has been held that they will be entitled to every legal right, including the fundamental right, just like other genders like male and female. Third genders, transgenders will be given all legal as well as the constitutional, including the fundamental rights like the other genders of the nation. So this is a very landmark judgment in the Indian history जिसने transgender को a legal recognition दिया था, and they have been considered as the third gender under the Indian society. In the case of Justice K.S. Puttaswamy, retired versus Union of India and others, whose judgment came in 2017 by the Supreme Court, it was 9 judges bench. This case may right to privacy was held to be a part of fundamental right. यानी in the case of Justice K.S. Puttaswamy में Supreme Court ने held किया कि right to privacy is a fundamental right, as it is an intrinsic part of right to life and personal liberty under Article 21. तो Article 21 में right to privacy is the intrinsic part of one's own life. Hence, कोर्ट ने MP सिंह केस और खड़क सिंह केस को ओवररूल कर दिया in this judgment because they denied the fundamental status to the right to privacy. And through this case, which is popularly known as the Aadhaar case, Justice K.S. Puttaswamy versus Union of India and others, right to privacy को बोला गया कि it is the one of the fundamental right as enshrined under Article 21 of the Constitution because it is the intrinsic part of one's own life and liberty. So right to privacy has been given the fundamental right ka status through the judgment of K.S. Puttaswamy in the year 2017 by the 9-judge bench. In the case of Joseph Sain versus Union of India, citation is 2019 Supreme Court, whose judgment came on 27 September 2018 by the 5-judge constitutional bench of the Supreme Court. They have struck down section 497 of the IPC, which criminalizes adultery. So through this judgment, adultery has been held to be no more a criminal offense. So by the judgment of Joseph Sain versus Union of India, 5-judge constitutional bench have held that adultery is no more a criminal offense. Act of adultery means when a man commits sexual intercourse with a married woman, not the wife of that man, with the consent of that married woman, but without the consent of the husband of that married woman. It is the act of adultery. If a man commits sexual intercourse with another married woman, not the wife of that man, with the consent of that woman and without the consent of that married woman, then it will constitute the act of adultery. Act of adultery was considered prior to the Joseph Sign judgment as an offense, because section 497 of the IPC is a gender stereotype provision जो कि women को chattel बनाता है in the hands of the man, which violates the article 14, 15 and 21 of the Constitution of India with respect to the woman. Right to equality under article is being violated. Discrimination on the ground of sex is prohibited by article 15 of the Constitution, which is being violated, as well as the right to live a dignified life under article 21 is being violated when we put adultery as an offense. इसलिए कोर्ट ने struck down किया section 497 of the IPC which criminalize the act of adultery, और कोर्ट ने बोल दिया कि adultery तो अब कोई भी criminal offense है ही नहीं, because it violates the article 14, 15 and 21 of the woman. Adultery is a gender stereotype provision which exists in the IPC. That's why it has been struck down and held unconstitutional in the case of Joseph Sign versus Union of India by the 5-judge constitutional bench. Now there is one practice question for you with respect to the landmark judgment जो कि हमने अभी देखा है, and the question stands as, which article of the Constitution of India deals with the right to privacy as a fundamental right? So you have to tell under which article right to privacy has been held to be included is there under option B, and C says that article 19 के अंदर right to privacy is there, whereas the last option article 21 में that is given. So you have to tell which of the following article 14 as per option A, option B article 16, option C provides for article 19 and the option D provides for article 21. So you have to provide the answer for this question कि which out of these 4 articles provides that right to privacy is included as the fundamental right, and under which article. तो आपको बताना है कि किस आर्टिकल के अंदर right to privacy has held to be a fundamental right by the Supreme Court, whether it is option A, B, C or D. So please tell the answer in the comment box. Happy Independence Day to all. Thank you.